Good morning, everyone. I'm staff attorney. Thank you for joining us on very short notice. I know the judge is in her office and knows this is getting underway at 9:30, so I expect her to be on any moment now. So just sit tight. We don't have a court reporter, right? Shake your heads no. Okay. No, I didn't think so. I just had to check before we got underway. All right. She should be appearing in 1 to 2 minutes, so we'll see you then.
Thank you.
Good morning.
Morning.
Morning, Judge.
Okay, so I understand that we are here. I think this is what I understand. So the plaintiff in this case, which is a corporate entity, right?
Correct.
That in the course of depositions, this individual, Mr. Lennon, who used to be, or I guess was a principal of a prior iteration of a corporate entity, is not a party to this case and is not a principal or member of the corporate entity that is a party to this case. Is that correct? So far?
That is correct.
Okay. And that the issue is that Mr. Lennon, who I, in fairness to Mr. Fallon, understand is the one who hired Mr. Fallon to act on behalf. And granted, that doesn't change the privilege issues and obligations that would flow to the plaintiff, but I understand that Mr. Lennon is the one who hired Mr. Fallon to litigate this matter on behalf of the Concourse Club. And that,
Judge Cross,
yeah,
that is not true. I know that is what Mr. Fallon represented to the court yesterday, but I have correspondence from Mr. Fallon in writing as of last week that said he does not represent Mr. Lennon. That was last week. This
right.
case
I didn't say that he represented Mr. Lennon. I said what Mr. Fallon had represented in his email is that Mr. Lennon is the person who hired him to represent Concourse. Just as if I could hire a criminal defense attorney to represent somebody that I have no relationship to defend them. Doesn't create an attorney-client relationship between Mr. Fallon and Mr. Lennon, doesn't make Mr. Lennon a party to this action. I was just acknowledging the nature of that connection.
okay, thank you.
Yeah. And where I understand this matter has broken down is that Ms. Rowland has graciously allowed Mr. Lennon to appear continually at proceedings involving this case and depositions where he is providing guidance and counsel, as perhaps a client would do, to Mr. Fallon regarding factual issues, which Mr. Fallon acknowledges in his email that he sent to me about what he thought the issues were. And Ms. Rowland is objecting to Mr. Lennon's continued presence. So that's sort of the general background I have and where I think we are. if you can do, I have read, the reason I give you all that background is to let you know that I have read the emails that you've shared with me. So you don't have to reiterate to me everything that you've already shared in the emails. But Ms. Rowland, if you want to let me know what your primary concern is and what it is that you want the court to do.
So my primary concern generally is the integrity of the process. So if Mr. Lennon, and from what I understand from Mr. Fallon's email, is that essentially Mr. Lennon is going to be the plaintiff's primary, star witness. And yet what is going on, and I want the court to know that I didn't find out from plaintiff or otherwise about really what Mr. Lennon's role was. I found that out by happenstance because another non-party to this case, who has filed suit against a separate suit against Mr. Lennon and others, has allegations that Mr. Lennon was not a member. But Mr. Lennon just showed up to the deposition, so I wasn't. And when I say this, I'm talking about a third party deposition for someone who has a very difficult schedule and was preparing to leave the country in within the next few days or a week or so. And so I needed to proceed for it also because discovery ends on August 8th. But it is apparent to me that, so for instance, when Mr. Lennon is showing up, he's showing up with his own documents, and it is even more problematic to me, Mr. Fallon's explanation of what Mr. Lennon's role is, because it is not Mr. Lennon's job to tell counsel whether or not the witness is misstating the facts. That's going to come out either in an affidavit or it's going to come out in testimony at trial. That's for the jury to decide who's credible, who's not. Let the witness say what the witness is going to say. And then if Mr. Lennon gives his testimony, then the jury is going to decide who they believe and who they don't believe. But it is not appropriate, in my estimation, that Mr. Lennon would be instructing counsel while the deposition is going on when he is not designated as the corporate designee. Mr. Fallon could have designated him as the corporate designee, but he did not. And I don't have an objection to the corporate designee being in the deposition because the corporate designee has a right to be in the depositions. But I do have a problem with a non-party being privy to all of the testimony when we all know that if this was a court setting, that this is a witness that would be sequestered. He would not be privy to the testimony of other witnesses. And that's why I say I'm concerned about the integrity of the process, because I think what we're potentially setting ourselves up for is maybe even some appellate issues with respect to Mr. Lennon and him being privy to that testimony prior to actually giving that testimony at trial. And I think if he is, I have no problem with what he knows or how much he knows. That's really irrelevant to all of this. But I do have a problem that he is going to be the star witness and yet is listening to all of the testimony and then directing. Essentially, he is, by Mr. Fallon's own admission, he is essentially the lawyer he's the non-party witness that is essentially directing the deposition of, and mostly my client is the one that I'm mostly concerned about, because he hasn't really said much in the other depositions. But in my client's deposition, I think that's problematic. I think it's prejudicial, and I don't think that it is. I just don't think it's right. I will point out that OCGA 911-30C1 points out that in these depositions, you can examine or cross-examine witnesses in accordance with the way that you would do so at trial. And then if you go to OCGA section 24-, 9-61, that is the right to sequester witnesses. And so if we're talking about that you can examine these witnesses the way that you would do so at trial, and then you invoke 24-9-61, which is the right to sequester them, then I think that Georgia law gives me the right to make that objection.
Okay. Thank you, Ms. Rowland. Mr.
Thank you.
Fallon?
Yep. So a couple things. One, some more information since it just came up, in a hurry yesterday. But it's 24-6-615, exclusion of witnesses. This number one, she said if this were a trial, it's not. It's the very last deposition, and Mr. Lennon's already been deposed. So whatever he's going to say based on what he's ever seen has already happened. His deposition's already been taken, and the only thing remaining is the main defendant. Number two, she said it'd be fine if he was a corporate designee. And earlier this morning, I had a chance to talk to the managing member of the LLC, and he confirmed that Mr. Lennon is the vice president of legal affairs for the company, and he is the corporate designee. So that's the company, like she said, is entitled to have a corporate designee, and it's
Has the company's 30B6 deposition been taken?
Pardon me?
Yes.
Has the
Yeah, everything's done except the final defendant. And she said that, however much Mr. Lennon knows isn't a problem with her, I guess, as long as he doesn't tell me during the deposition his opinion of what the other side is saying. And that doesn't make any sense. He's.
Okay, so let me back up for a minute. I mean, I don't necessarily disagree with you, Mr. Fallon, generally that absent, unique circumstances, the ability to consult with someone, whether it's a consultant or a client or whatever, is pretty, open season, and that generally speaking, depositions are, non-public events where we don't usually have people present, but, we're all, I don't know about y'all, but I've certainly, we're all pretty forgiving about who shows up. I think what I am a little concerned about from Ms. Rowland's perspective, though, is this some sort of 11th hour adjustment? I mean, because the 30B6 deposition has already been taken at the corporate designee, and it's not Mr. Lennon, but now it is Mr. Lennon, and Mr. Lennon's deposition was taken as an individual non-corporate designee who didn't have the power to bind the company to his representations, but now they're going to say, oh no, Mr. Lennon is the designee. Is that what I'm understanding now?
Well,
also, before you answer that question,
yeah.
Let me back up and say this. What is Mr. Lennon's role, and what historically has been Mr. Lennon's role with the plaintiff during the course of this litigation? Because I thought that he was retired from and no longer working with Concourse.
No, I mean, when they did the transaction to sell the company, I mean, he was part of that was to buy out the shares of the principals or whatever. And the last one is still there to kind of wrap things up and do whatever. It's not really doing much. But as far as that's sort of on paper. As far as the practical day-to-days, I mean, he's still, one of the main person. And with regard to this particular witness, first of all, Mr. Lennon was at the 30B6 thing and working on the documents and everything there and all of that. And it's not like
hang on. So, Mr. Fallon, you didn't actually answer my question, right? So, because to me, I think maybe it matters. Is Mr. Lennon currently employed by Concourse? Does he have a role? Because you just said, oh, well, now he's the vice president of legal affairs and he's going to be the designate. What is his job for Concourse, and when and how were the circumstances of him having that designation, job?
Yes, Your Honor. The circumstances are that the managing member of the LLC, who still is, I think, the only member on paper of this company, said that he wants Mr. Lennon to be the company employee of whatever it takes to be able to participate in the deposition of the main guy who Mr. Lennon was the one that had all the interactions with while this transaction was going on.
But it sounds to me, Judge, that just happened yesterday after they knew this hearing was, because I just took Mr. Lennon's deposition on Wednesday, and he said he had no relationship to this company whatsoever. He just wanted out. He wanted to get paid out and get on from this company because there were multiple individuals that he had conflicts with. He wanted nothing to do with this company. So this is new. This is completely new. He's got a new role all of a sudden as of last night.
Mr. Fallon.
Yes, because no one objected as of yesterday. He was at 2 prior depositions, and there wasn't any problem with this. And I mean,
there was a problem, Mr. Fallon, and you know that.
Hang on.
that's not the point.
Hang on. Okay. So, I think there is a little bit of, I'm not a huge fan of whatever maneuvering is happening with Mr. Lennon relative to concourse. However, what I am struggling with is if Mr. Lennon really is the principal target, and really is the person who knows the most and can be the most educated. The issue I have is why was he not designated as the corporate designee before now? And what does that do to the case if the corporate designee's deposition has already been taken? Yes.
So the reason that the answer to that question is simple, is that the corporate designee was lots of other questions that the main managing member was the best designee for. And in fact, Ms. Rowland and I had a conversation about that. I'm like, well, in some ways, Mr. Lennon here would probably be the best person for some of the questions, but the overall corporate designee made sense for, there was other questions besides the questions related to this particular transaction with this particular defendant that's about to be deposed. Does that make sense? Do you see what I'm saying? And I have a second point too, but that's the main thing, is that overall there's other things. But with regard to this defendant, Mr. Lennon is the one that had most all of the interactions with him and really has all the knowledge about it, and to be able to tell me what this document is or what it means or whatever. He's really the main person that interacted with him. And secondly, I don't understand the harm at all, because his testimony is going to be a trial. He could read the transcript. There's nothing that's going to happen other than a document will come up. I won't know what it is. He won't be there to ask. And I would normally ask him what it was, and he would tell me, and he'd say, great, then I would know what to do with that. So he's really, for the company, the one that has all the information in his head about this transaction, that he was the one that dealt with this particular deponent who's the main defendant. But as far as the corporate and in the previous 30B6 deposition, there's lots of other questions that would come up that the main managing member would really have been the main person for.
Well, and Judge, if I can speak to that point, that is the whole purpose behind when you do a 30B6 deposition, you give the topics that are going to be that the witness should be prepared for. So Mr. Fallon, being that he has access to Mr. Lennon, was to prepare his corporate designee for those topics, which I gave him at least 2 weeks in advance of the deposition. So he should have prepared his corporate designee, whether it was Mr. Lennon or whether it was Mr. Garelick, on the topics that the other person didn't know. But what the rules don't allow, at least I think I'm correct about, is that you can't have multiple designees because one person has information about this and then another.
Oh, you definitely, well, let me interrupt you there. I've definitely represented plenty of corporations where I had 4 different corporate designees because there were 27 areas of inquiry, and I was like, they know this, and they know this. My concern here is that while practically speaking, it may have been obvious that Mr. Lennon is highly knowledgeable about some of the issues in this case, I am a little concerned about the fact that he is gaining the benefit of a front row seat to all of the depositions. But I also question, while it is annoying, It doesn't sound as if it is disruptive in any manner, any different than a lawyer having an employee of a company sitting there telling them, you know, hey, this is what actually happened, just like they would have their client sitting next to them. And so the issue then becomes one of whether or not the rule of sequestration applies to depositions, which my very quick efforts at Googling and Westlawing have not located cases that say that the rule of sequestration applies to depositions. And so then what that means is usually the remedy associated with a lack of sequestration is that is a matter ripe for cross-examination of that witness. In terms of Mr. Lennon being cross-examined on the fact that, you know, he is the mastermind behind all this and sat in all the depositions. So of course he knows all the answers to everything because he sat through all the depositions.
So meaning it would go to his credibility.
Right. It would go to his credibility at trial. I'm just not sure that there's a basis. I mean,
Right.
Absent him being a disruptive presence, which while I understand Miss Rowland and I don't mean to minimize the nature of his presence. And if in fact he did threaten to call your founder of your firm, that's a pretty jerky thing to do. But I don't want to minimize that, but it also in fairness, in your candor of characterizing the circumstances, it doesn't sound as if he is a disruptive presence. He's simply sitting there assisting the management of the deposition in the same way that an employee would. The only issue is he's not an employee because of, you know, whatever his issues are. I think it is too cute by half that suddenly today he is the VP of Legal Affairs, Mr. Fallon.
Of course, but
Those are all matters that we can sort out at a later time, at trial, etc. What I'm going to say for now is that so long as Mr. Lennon's presence continues to be in aid of counsel and is not disruptive or disrespectful, then he can continue to attend the depositions. But that the fact that he was present for all of this when he may or may not have actually been able or authorized to be there is a matter that will be certainly open to Ms. Rowland's ability to cross-examine the witness regarding how and why he knows the things that he knows. That's going to be my ruling today. Anything else that y'all need me to address while we're here, Ms. Rowland?
Judge, I don't have anything else, but I do appreciate you taking very short notice of this and allowing us to be heard.
Mr. Fallon, anything else?
real quick, just to ditto that for short notice, make yourself available. Always appreciate it. You probably wouldn't remember, this case was originally filed because there was other defendants that had filed false UCC ones because they thought they were owed some money, and they had just filed these UCC ones that were preventing the closing of the sale.
That sounds vaguely familiar. Yeah.
And you had agreed to do an emergency hearing. I spent the whole weekend drafting this emergency motion and the whole complaint and everything. And then they agreed to just get rid of the UCC one, set the hearing. And so, and then I dismissed them without prejudice, because that's why they were kind of there. Well, now they've sued us separately for this commission that they said that they were owed and that we don't want to pay because it's based on the whole, the reason I mention it is because they've sued us and didn't mark that it was a related case, and now it's in a separate thing, and I'm not sure. Anyway, it might be coming back to you, I would imagine. I'm not sure if the other judge sua sponte or if I need to. They didn't check the box on related cases, so it got assigned to someone else, but it really should be, you know what I mean? And so you said if there was anything else in the matter, about while you're
Ms.
here.
Rowland, are you counsel in that case relative to those other claims? Okay.
I am not, and my client is not a named party in that case. We don't have a relationship to that case.
Well, let me say this, to the extent that it, generally speaking, is not my intention because of a related case or otherwise. If their issues are secondary and not compulsory counterclaims, et cetera, that are required to be resolved here, I'll take a look at all that. And it may be that case will end up with me, and then I'll have lots of good knowledge for that case, but it's not going to change the procedural posture of this case in terms of discovery, closing, and its track for trial. So
Oh, okay. Yeah, I guess so.
I was just letting y'all know because I mean, I do think I need to, Mr. Fallon, you don't by chance have the case number on that, do you? Or the, one of the named parties that I could find in our Odyssey system?
Yep. Yeah, I have it right here. It's she might get it faster. Well, it's the Concourse Acquisition and Development is the defendant, and Ray Rothman and Rothman and Associates.
RAY.
Yeah,
Ray.
RA. Mm-hmm.
Okay, let me see if I can find it real quick.
Oh, here it is. New complaint.
Let's see.
24 CV 008025
24 CV 00
8025.
8025. That's funny because when I search Mr. Rothman's name, this case comes up, but the old one does not.
And it's a woman. Ray is a
Yeah, it's only the company is the plaintiff, Rothman and
Oh,
Associates.
that's why. Okay. Okay. But I've got the case and I will figure out, I can probably just notify the judge that it needs to come to me. But if something doesn't move, it may be that if the parties care about it, that you might need to file a notice of related case in that case or in this case so that there's some record, but probably I can just reach out and let the judge know. And I'm sure they'll be perfectly happy to say, here you go, one less case for me to deal with.
So,
And send it over to me, but I'll look it up and figure that out. But as I said, I would fully expect that that would be something that's secondary to this, and it's not something that I would necessarily consolidate, etc. So 8026, you said?
8025.
25. Thank you. 80.
It's Judge Leftridge, Judge.
Oh, okay. Well, I'm sure she'll be perfectly happy to hand it over. Yep. Okay. Well, I will reach out to Judge Leftridge. And other than that, good luck with y'all's deposition or the remainder of the deposition. If you need anything else, I do try to make myself widely available. So if issues come up, let me know. Otherwise, I know your discovery is about to close. So I guess I'll be looking for probably motions practice from you guys, and then we'll go from there. Okay.
Thank